All right. So what do we want to address that now?
We can, Judge. This is a case where I represent the petitioner moving party. All he's saying, and this is one that you reviewed this morning, saw that it's been filed since about late April. My client has the kids here in Washington. Mr. Sane is presently, I think, overseas, but lives primarily in New York. My client's been kind of patching it together month to month. I understand with limited funds. Given this has already been set over once by Mr. Sane's request several weeks ago, we are asking if the court is inclined to set this over, and I certainly understand Ms. Bliss's position at the late notice being retained, but we would ask that you consider some form of financial support be paid between now and whenever the court finally hears this case, whether it's later this month or early next.
So how much time how much time are you looking for, Ms. Bliss?
And Your Honor, I did discuss with Mr. Zandy potentially the August 6th date. I'm out the last week of July, and I think the next docket or the next two dockets I think is too short of a timeline to provide either Mr. Zandy or myself the ability to appropriately prepare responses and replies. So my request would be August 6th.
So that's about a month out. And if the court's good with that August 6th date, I am too. The only issue is my client's here locally with two young kids that she's supporting. Again, got new information from Ms. Bliss today about a community credit card that they've been kind of living off of, which I understand will be probably subject to her responsive materials. But we did make a request for maintenance in our petition. We did make a request for child support in our petition to motion, and also for some fees and costs. And again, this is a case that I think was originally docketed for sometime in early June, set out to today's date so Mr. Sane could retain counsel. And then this morning, to Ms. Bliss's credit, she did reach out to me and say that she had been retained very, very recently. So this is now going on 2 months from the original date of the motion being heard, that my client's kind of hanging out in limbo, and I would like to get her some form of financial relief if we could, pending that next hearing.
Okay.
And Your Honor, if I may, as Mr. Zandy indicated, I was just retained this morning. My notice of appearance hasn't even been entered yet. The information I have from my client is very minimal, but as I discussed with Mr. Zandy this morning, it is my understanding that there is a community credit card that my client essentially allows Mrs. to use for living expenses for the children, and then he pays off that credit card, or nearly pays off that credit card every month. And they've been doing this, from my understanding, for quite some time now. I would just ask the court to essentially reserve on any further findings other than allowing Mrs. to continue using that credit card pending the next hearing.
All right. In terms of that, I don't feel like I have a lot of information here. I've got petitioner's worksheets. I would order him to pay $750 this month toward child support. And then we can take it up again on the 6th.
And then in addition to allowing her to use that credit card as they've been doing, if you looked at our motion, we did reference that.
Yeah,
okay.
It's in addition to that. So but if he could have that paid by the 16th, and then we'll take this up again on the 6th of August.
Very good. Thank you, Judge.
Sure.
Do you want to, don't log off just yet, Ms. Bliss. Do you want to craft a bench order to that effect, Judge, or do you want me and Ms. Bliss just to kind of nail that down through an email and CC you on it? What's your preference on that? Or should we just go off of what reflected in the clerk's minutes, and if he doesn't pay, we'll take it up on the 6th? That might be the easiest way.
All right. Well, yeah, why don't we do that? Just go with the minutes.
Okay.
The minutes.
Well. Thank you.
And just if we make sure the minutes reflect that 750 order by the 16th for child support. Thank you.
Thank you, Judge.
Sounds good. Thank you.
My understanding was that this was just on to make sure that the ad items report had been filed. And I received a bench copy of the report this morning and read it. Let's see. Oh, I need to let in this folder. I did receive Ms. Corey's ad litem report. My understanding is this was just on to review. And I'm not sure.
Yes, Your Honor. This was on for review. The parties did receive her report on the 7th, so 2 days ago in the evening. So we're asking for a set-over to allow the parties enough time to respond for the court timelines. And I believe the judge that was assigned to the case needs to hear the matters. He's already made some substantive rulings. And I would like for Ms. Corey to give the full review at the anticipated set-over hearing. That way the court has any amended parenting plans in front of it. Some substantial things have happened since the original parenting plan was filed back in December. So some things have changed in the parenting plan that we proposed will need to be amended.
Okay, and I don't know what Judge Basher's practice is if he requires, in terms of changing the current parenting plan. I know that I would require motions, even with the filing of the report. That wouldn't automatically kick in, I guess, the ability to change what was happening right now.
Yes, Your Honor. In this particular case, there is no current parenting plan. There's only a temporary family law order in place. We proposed the parenting plan, and Judge Basher wanted a GAL review to determine if the parenting plan we had proposed would be acceptable. And so that was why the GAL had been assigned. But some things have changed. Our client has moved to Arizona since then, so it would change some of the functions in the parenting plan.
Okay, so how much of a set-over are you looking for, counsel?
I believe 2 weeks would be appropriate, would give the parties enough time to respond on their own, and then it would allow both parties to digest anything that the other has filed.
Mr. Fowler, do you have any input on that?
No, Your Honor, I do not.
Okay, I will set this 2 weeks out, so that'll be July 23rd at 1 o'clock in the afternoon.
And that matter's ready, Your Honor. Your Honor, we're here on a motion for adequate cause and a motion for temporary orders. The original parenting plan was filed back in March 25th of 2020. Since then, there's been a significant change in circumstances for the children, also the mom with residential time. I represent Mr. Kautz. What's essentially happened, and I'm not sure if Your Honor read the voluminous amount of materials here.
I read everything. I did, for the record, I did read everything within the limits of our local court rule 88. I didn't read responsive pleadings that exceeded the limits, and I'm not considering those.
And just to clarify for the record, I confirm with Judge Basher that he wasn't, and presumably Your Honor is not going to consider the reply declarations of Linda Kautz, Jennifer Mickelson, and Isabella Johnson. I just wanted to make that clear for the record.
Linda Kautz would be acceptable. We're allowed 1 page on reply.
You're allowed 4 total pages, and I believe your client's declaration alone was 4 pages.
That was my read of it as well. Mr. Kautz's declaration pretty much took up the limit.
On his reply, are we not allowing the headline note then to count anymore? Is it just going to be 4 pages and that's it? It's not going to be 4.5 pages like it used to be? I'm just curious, because everybody has kind of a different take on that.
Well, I read this last week, so whether it's 4.5 but it seemed to me that it was right there.
Okay, and that's fine. I can argue with what I've got before me.
All right, go ahead.
Yes, significant change in circumstances. So when this first happened, essentially mom ended up, and you'll read the declaration, immediately upon the final order being entered, mom was in a relationship with a man she's no longer in a relationship with. There was a domestic violence incident. Mom, there appears to have been methamphetamine in the house. That man went to jail. That man was arrested, out of her life. In 2021, December of 2021, mom moves in with Jeff Mickelson. Now they're not married. She did change her name in district court, but they're not married. She moves her and the two daughters. There is McKinley and Denali. McKinley is 11, Denali is 8. She moves them into the house with Mr. Mickelson. At that point in time, prior to that, McKinley, which is really the child we're going to focus on now, that's the 11-year-old, McKinley had some behavioral issues at school, normal for an 11-year-old. You'll see in the medical records, these were normal disruptive behaviors. You'll also see that all of the counselors from about 2021 to about the mid of 2022 reported that they saw maturity in her. They saw that she was no longer being disruptive. You can see these in the sealed medical records. Dr. Leah states that McKinley is doing well in school, that she's not nearly as her behavior is good. She's starting to mature. What we see in 2022, immediately after moving in with Mr. Mickelson, is a complete degradation of her mental health. This is a child that went from having normal outbursts, being kind of emotional and maybe trying to get her way, things like that, to being a child who has been hospitalized for suicidal ideation, who has been on Prozac, who is now on a different medication, citalopram, who has threatened to kill her mom, who has been into fist fights with her mother, who has been into significant altercations with her mother over hair pulling.
Well, I object to the argument. Father has no personal knowledge of what's going on in my client's home, and there's no indication that there's fist fights or anything of the like occurring in my client's home.
And I can answer that. It's in my client's declaration. They were brushing the child's hair, and they noticed that hair had been pulled out. And you'll also see the text messages from the mother.
Okay. All right. Well, I'll address this when I rule.
Okay. Essentially, it's, as much as we want to say mom is bad, that's not the issue here. There is something fundamentally wrong with what is going on in mom's house. And this is the relationship between, I'm going to call him for all intents and purposes, the stepfather, between the stepfather and McKinley. Something is going wrong that is adversely affecting this child in such a way that her self-esteem is completely gone, that she is suicidal, that she is angry, that she is having outbursts. And I've highlighted or underlined some important things that the counselor noted about this relationship. The counselor suggested that both of the parents take CPS classes. And the reason she suggested that is to essentially learn how to parent this child and to find out what was going on. The child related to the therapist, and these are in the notes under seal, that she was afraid to disclose anything about stepdad because mom was, and I quote, going to yell at me. She also stated that her mother's partner, Jeff, treats her differently and that he has yelled at her, which is upsetting. She states that her mother leaves her for hours and hours. She gets out at 2:45 of school. Mom doesn't get home till between 6 and 6:30. She leaves them with Jeff. Jeff is retired. He lives there. Jeff goes in the shop. Jeff says mean things. Essentially, she's stating that the child is stating that he's extremely mean to her, that she's upset, that it's making her suicidal. If you notice from these records as well, that she's uncomfortable when she stays at her mom's house due to the presence of mom's boyfriend. She's losing emotional control. She needs to be surrounded by strong role models, is what the counselor states. The counselor also states that McKinley has been on medication since February of 2020. While it does have some beneficial effects, it's clear that there are expressions of suicidal thoughts. And this is very, very important. This is from the 2024 visit with Dr. Leah over at Kaiser. She states that The expressions of suicidal thoughts are related to certain situations that the patient finds stressful, specifically as they relate to her stepfather. Mom acknowledges this and says she is working hard to address this. We don't see any of that being addressed. The child also discloses later that they continue to not get along, that mother's not doing anything, that mother is siding with the stepfather. Something is happening here, and I, as the attorney, I'm not one to hazard a guess. We can't use child hearsay. The child feels, as she stated to the counselor, she doesn't feel safe disclosing, but something is making in that house, something to do with the stepfather has become incredibly problematic. Again, on 128, child, essentially it's stating, the mother states that father observes different behavior and child has different behavior at his house. That's from the 118/2024 note. Child also disclosed she's having bad thoughts. She has difficulty with her relationship with her mother. Essentially what we have here is a complete breakdown of the mother-daughter relationship. We have a child who feels that the stepfather is unsafe. The mother isn't doing anything about it. The mother is leaving this child with the stepfather for 4 hours, 3 to 4 hours at a time. Now, mom can't seem to handle this child. When the child's at mom's house, we have hospital visits. We have child threatening to kill mom with scissors, and you can see that in the counseling records as well. We have child threatening to kill herself. We have hair being pulled out. We have essentially just anything that can happen wrong is happening wrong. Mom calls dad and asks my client, can you help? My client keeps trying to help. We have my client talking to the child. My client is the one doing all of the homework assignments with the child. And my client has discussed this with mom. Why can't you get this done? And mom says, well, by the time we get home, it's too late. I can't do it. Mom has her own significant history of mental health issues. As your honor will know, mom has a very significant history. And we have a place right now where it would be great if this was all just the child kind of making things up and just wanting attention. But nobody knows if that's the case. This is an 11-year-old. This isn't a 16-year-old. This is an 11-year-old that is clearly crying out for help. This is an 11-year-old that if we do the wrong thing here, the outcome, if we do the wrong thing, could be this child hurts herself, harms herself, kills herself. And that is why it's such a significant issue here that a GAL must be appointed. Adequate cause needs to be found because a GAL needs to investigate what's actually going on here. Is this child just overly emotional? Because Dr. Leah isn't a psychiatrist. That's the one thing. She is a pediatric doctor at Kaiser. The child's been referred now, but these medications, the Prozac and things like that, these have not been prescribed by a psychiatrist, a pediatric psychiatrist. The child does have a referral now. But the fact is that really a GAL is the only one who can get through all of this. Now, what you're going to hear from mom today is mom's going to say, well, I asked him to come over on Tuesdays and to just chauffeur them around so they don't have to be by Jeff because her husband or the stepfather refuses to pick them up anyway. But the fact is as the court or as the counselor notes, these transitions themselves are causing some of these issues. The transition, child is stating she doesn't want to go to mom's house. So what happens when dad picks her up on a Tuesday or that Friday for that weekend is when the child has to go back to mom's, the child's fine leaving dad, but the moment the child gets to mom, all hell breaks loose because the child is very angry, and she states that in her declarations that she's angry that she doesn't spend as much time with her dad, that she's angry that she has to be at mom's house, and that the mother's boyfriend continues to be rude, and essentially she just breaks down. Denali has also reported similar things, but nothing to this extent. Really, McKinley is the one kind of at crisis point. McKinley was hospitalized recently during this hearing, which is why we did file all the other declarations rather than doing new declarations. If your honor is not going to address any of that hospitalization, I know mom's going to state it was something that happened at school. The fact is if you look at all of the dates of all of these suicidal ideations, these thoughts of harm, all of these things, they all occur during mom's time. You can also see that when dad brings the child into the counselor visits, the child discusses what's happening. Dad's not in the room, and all says it comes back to her relationship with mom and especially the stepfather. What is happening between these two? When she's with mom, she shuts down completely. And she states that she's afraid that she's going to be punished when she gets in the car if mom hears that. And you can see that clearly on the counseling records as well. My client does work on a tugboat. The 2 weeks out of the month, he is there the remainder of the time. But you'll also see in all of the records at this point that his partner, his wife, gets along great with this child. The child's actually asked the counselor to include his wife in the counseling sessions because she gets along with her so well. The fact that she wants to include this, and normally we'd say, well, we don't want dad to delegate his parental functions for a couple of weeks to this person, but this isn't about trying to steal mom's parenting time. This isn't about trying to take anything away from mom or give it to somebody else like a stepmother. At this point in time, it's about protecting this little girl. She is getting worse. She is getting significantly worse. The change in circumstances is Mr. Mickelson. The change in circumstances is a child that's now threatened suicide on about a monthly basis since January of this year. These are the significant changes. Adequate cause is absolutely here. I'd ask that the guardian ad litem be appointed today to investigate this, to look at the medical records so we can see what we can do. If that means some reunification with mom, great. If it means that dad keeps child for a month until things settle down, great. But really, we need a professional here to assess, and these parties just can't come to an agreement. So we'd ask Your Honor to grant adequate cause, to allow our parenting plan, which at least gives no transfers and has mom just the last 2 weekends of the month. But if Your Honor is not willing to do that, somehow we need to minimize these transfers, but we also need to protect this child from this unsafe feeling she feels when she's around Jeff Mickelson.
Thank you. Ms. Gilmore?
Yes, for the record, Megan Gilmore on behalf of the petitioner and non-moving party, namely Beth Mickelson. I'd first like to note, and I didn't object, I appreciate counsel's zealous arguments, but I think that she grossly mischaracterizes on multiple occasions the medical records, and I do ask the courts to thoroughly review those before making any sort of determination today. Father seeks a major modification of the petition and substantially asks to limit my client's visitation within his petition. However, in reality, Father actually wants to maintain the current schedule, which largely gives the parties 50-50 with minor modifications by particularly removing Tuesday visitations in that second weekend of the month that my client has weekend visitations during his residential time. Father has no basis for a minor modification. Therefore, it's our position that he's exasperated the child's problems with mental health that frankly have been going on for years prior to and following this dissolution in support of a major modification that just simply isn't warranted in this case. As the court is aware, the standard for a major modification is high. Pursuant to RCW 2609-260, Father must prove that there's been a substantial change to the non-moving party, my client, or the children, and his proposed visitation schedule is in the best interest of the children. Father brings this action with unclean hands and simply no change in circumstance. The child in this case has been in mental health treatment and prescribed mental health medication since 2017, so roughly 3 years prior to finalization of this case, not 2022 as argued by counsel, while the parties were still married. The child has continued to have ongoing issues with mental health, as described with the records that go far back as 2017, and my client is submitted under seal. As the primary parent of these children, my client has worked around the clock with the child's providers for the best interest of this little girl. As detailed in the records, the providers have commended my client for her diligence and determination to do everything necessary for her daughter. As Father no longer wants my client to have Tuesday overnights or the second weekend of the month, he tries to create a nexus between the child's historical mental health problems and my client's significant other. My client has engaged in a relationship and has been living with this individual for 3 years at this point. As witnessed by Father's own communications to my client via text message around the same time, he acknowledged that it was a great decision for my client to be in a relationship with this individual, and that he specifically said that there's no problems with him being around the children. This is his own message from 2021. It's also important to note that he was already in a relationship with Jeff's ex-wife that he's currently in a relationship with at this point. So if there were any of these allegations regarding abuse or misconduct were true, going as far back as 2005, he wouldn't have had this position in 2021. The records also make it clear that Jeff isn't the cause of this child's problems with mental health. My client would like to avoid unearthing the child's private disclosures, but is forced to do so in defense of father's baseless allegations. The recent records make it clear that this child is triggered by authority and by not getting her way. In recent months, her outbursts have been associated with getting into a fight with a girl at soccer and having a conflict with a teacher at school, which resulted in the hospitalization, as made very clear within the hospitalization records. This child wasn't taken into an IETA. My client took her to the hospital when she became concerned, as she acted appropriately. The child acknowledged that she was triggered by not getting her way at school, and made zero reference to Mr. Mickelson or my client's home or my client's relationship with the child whatsoever. So my client, in the recent incidents, my client's significant other hasn't been involved or even around whatsoever. On one occasion where the child recently committed suicide, my client's significant other was on vacation. So this simply isn't, there's no nexus between the child's mental health and my client's significant other. And frankly, it's happening at both parties' homes, as acknowledged within the father's own communications attached to my client's declaration. Father presents old records of the child voicing minor complaints about her stepfather. If he actually had concerns, he would have brought this action in 2022 when the alleged disclosures were made in the records. He's also asking for my client to have weekend visitation. Therefore, if Mr. Mickelson was such a risk, he would ask for no contact. Also, as the council acknowledged, his argument is weakened by the simple fact that he's not even willing to provide or help transportation or provide care after school while he's in town. He's in the correspondence, he's repeatedly saying, no, you have to deal with it. No, you have to deal with it. You have to choose a lane. Either Mr. Mickelson is a danger and the child shouldn't be around him, and you would then have the visitation, or he's frankly not, and you're acknowledging by your correspondences that Mr. Mickelson isn't a problem. The child also indicates in the recent health records that she's triggered by any change to her schedule. This is a fragile child here that has ongoing mental health issues that are not going to be resolved by a major modification and ripping her away from her mother. I think the records made it clear that there's not a problem with her relationship with her mother. The relationship is so close that she's disclosing and has some of these outbursts when she's around her mother. The records specifically acknowledge that she can't be open to father, and the counselor recommended that father be more willing to be open communication regarding the child's mental health during his time. I think the most important is that father simply has no ability to exercise the residential schedule he's requesting. He's out of town for half of the month, and that's not disputed, and he presents nothing to the court that supports his parenting plans in the best interest of the children. Being with a step parent for half of the month is not appropriate, and I don't believe the court has standing to give basically custody to a third party. We believe father brings this action in bad faith, and the act court award is substantial attorney's fees. Father was previously found in contempt twice. Since the final order was entered. He was in contempt for unilaterally withholding the children in 2022. Father's allegations regarding my client's drug use were false and unfounded at that time. It's also interesting to suggest that in his materials, his original declaration, he suggests that my client is the worst person in the world, a drug user, mental health problems, etc. Then he completely changes his tune in his latest declaration, acknowledging that my client is a good parent, but saying that it must be Mr. Mickelson, despite the fact that we have no evidence of abuse. Father was found in contempt for a second time in 2021 by involving the children in conflict and speaking poorly about my client. I would submit that any problems with the children that the children have with my client's significant other are based on father involving them in conflict and disparaging this individual during his residential time. Since filing this action, father has doubled down on this behavior by asking the children if they want to stay at his house on Tuesdays and suggesting to the children that my client was responsible for the divorce. Moreover, father's actions have only exacerbated the child's mental health issues. I think that it's made clear he fought with the child going on Prozac. When the child wasn't doing well on Prozac, he then refused to get off of Prozac. So again, at every step of the way with the child's mental health problems over the last year, the father has exacerbated the issues and caused problems to the point we have to get attorneys involved before we can get this child the help she needs. Father shouldn't benefit from his repeat violations of the court order and the chaos he's manufactured. There simply isn't a substantial change of circumstance warranting a major modification. The parties' work schedules are the same. They remain in close proximity. The children are doing well under the current schedule. My client has dated this significant other for over 3 years. My client continues to do everything in her ability to address the child's mental health. Unfortunately, this child has problems with mental health that aren't related to the actions of my client or her home. It doesn't help these parties that father is willing to discourage my client to this degree within an active litigation. As father didn't request for a minor modification, he should be restrained from seeking a minor change to the schedule at this point. He has failed to meet the standard for a major modification, and we ask the court deny his motion for adequate cause and dismiss his petition and award substantial attorney's fees.
Your Honor, brief reply.
Go ahead.
CP 83, I think, is really important here. If you look at page 12 of that, that is the hospital record showing when the child first went on medication. And that was February of 2023. And the reason for that is when the child first disclosed that she was feeling suicidal. That suicidal ideation was as a result of being with Jeff Mickelson. My client thought Jeff was a great guy. My client had no reason to believe any otherwise. And in fact, my client still doesn't think that there's probably any sort of abuse going on. He doesn't know, frankly. He's not there, as Ms. Gilmore stated. But something is happening. Is he a bad guy? No idea. But something is happening to make this child, even if she's softer than normal, a normal child, more emotional, whatever it is, there is something from February of 2023 that has made this child feel unsafe in that house. It also needs to be noted that they moved into that house in December of 2021. The issues, not the suicidal ideation, started exacerbating her mental health around that time. You can also see from those counseling records that the child was doing really well up until then. You can look at her 4/2022 that says that she's receiving extra attention at school. She's excited. She's acknowledged. She's more actively engaged in session. She's, and I quote, matured emotionally. And that was back in early 2022. And that's on page 6 of our CP 83. This all changes. And so at first it's this school, and then it all changes. Then we have child threatening with scissors, threatening to kill mom, threatening to kill herself. And child continually notes that it's her issues with stepdad. And it's not that mom is doing anything to her. It's that mom is not doing anything to stop this. And so child feels that mom doesn't care, that mom doesn't love her. It's broken down that relationship. Child is close to mom, that's her mother, but child is also threatened to kill mother. Child has also gotten into hair pulling fights with mother. And this is exacerbating. This is not where we want to have an 11-year-old. It would be different maybe if this was a 16-year-old that was going through teenage angst. This is an 11-year-old. There's something going on. Whether that's imaginary in the child's head or not, only a GAL can determine that. But McKinley and her younger sister are often in the home while Jeff is working his detached shop. It's unclear if mom is aware of this and if this is okay with her. They're often watched by Jeff because mom works. That again is on page 6 of that 35-page thing. The child was brought to the hospital by mom because child threatened to jump off a cliff and threatened to kill herself with scissors and refused to give the scissors to anybody and acknowledged where they were. Right now, it seems like a cry for help, but at some point that might change. And here is the biggest problem when it comes to these young people that even if they're crying out for help, oftentimes they think they can do something and harm themselves and somebody will find them and they'll get the attention they need. That doesn't always happen where they're found. And this is the problem. The child's in counseling again is going to be referred to a psychiatrist, but we really need a GAL here to identify what's going on. Dad is going to do anything he can. If dad thought picking the child up on Tuesday for a couple of hours would be beneficial, he would. But as you'll note from the counselor records, when that happens, the child loses it. These transitions are incredibly difficult. Dad would ask for full custody and not allow any contact, but my client doesn't want to ruin this relationship with mom at all. This is their mom, and frankly, mom is only a part of the problem and it seems like this relationship with Mr. Mickelson is the whole part. My client, his idea of doing this, just having 2 weekends a month for right now with mom, was to pull child out of that situation to see if things could calm down, to see if a counselor could step in, a psychiatrist, to see if the GAL, and see what's really going on. Maybe it's just too much contact with Mr. Mickelson. Maybe Mr. Mickelson needs to go to a parenting class. Maybe they all do need to take these CPS classes that have been suggested repeatedly by the counselor. In any event, this child's in a dangerous place. There's been a significant change in circumstances since December of 2020, which is when this was. Mom's in a significant change of circumstances. Everybody is here. So we'd ask Your Honor to order our temporary parenting plan, or at least to find adequate cause, assign a GAL here, and order a very quick turnaround for a very short interim report, so that we can actually identify what's going on and try to protect this little girl.
All right. I've reviewed the pleadings in this case, and adequate cause is a high standard. We have a situation where we've got McKinley, who's, as I read the record, has had issues with mental health going back for a number of years, and has been addressing those. And kind of the nature of those issues is they tend to ebb and flow. And people have better periods of time and worse periods of time. And she's struggled at times. Frankly, I didn't see a nexus between the child's issues and Mr. Mickelson. I think there's a lot of speculation about that, but really no facts that convince the court that the issues the child is having can be laid at his door, or really anybody's. So I'm not going to find probable or adequate cause. I don't think the standard has been met. I think there are plenty of records that show mom's trying to address these issues, and is addressing these issues. They just are not simple issues that just go away. And it seems like these are chronic issues. In terms of, I guess, the request for fees, this is a situation where mother has to marshal significant resources to address this kind of claim. And I am going to award $3,000 in fees based on the denial of the motion. Anything else I need? Anything else I need?
I imagine we can coordinate an order.
All right.
All right. Thank you, Your Honor.
Okay.
Thank you.
This is on for the Ms. Day's motion for counseling, individual counseling for
Lauren.
child, Lauren. And
Yes, Your Honor.
so Ms. Day, is there anything you want to say? I've read the pleadings on both sides, or I've read the pleadings
Yes.
that have been submitted.
Okay. Thank you, Your Honor. I appreciate that. Just very briefly, this case is highly conflicted, as you can tell, just by the nature of the case and some of the concerns here. I'm asking for the court to make a decision for the child for counseling. Previously, Patricia Anderson was assigned to be the individual counselor. The parents and the attorneys do not agree on who should be the counselor moving forward now that Ms. Anderson has stepped out. The child is definitely in need of some individual counseling. I'm asking for the court to determine where she attends counseling, taking into consideration the concerns of both parties. And then most especially from my perspective is to limit the amount of content that is provided to the counselor by any one person. My concern is that has been one of the main issues in this case, is an excessive amount of information being provided to the therapist, creating a preconceived idea about what's happening or what may have happened to this child. And I'm hoping for counseling to be just the support for the child. She can report the things that she has concerns with, make her own disclosures if she has any, and get the support that she needs in going through a very difficult process and a very conflicted parenting plan action. And that's the gist of it.
All right. Either counsel want to be heard?
Either, if I may briefly, Your Honor, Alyssa Miller on behalf of Alan Brown. I substituted in for Ms. Poplowski just today, so I'm not sure if the court has received that substitution quite yet. We had not filed any materials on behalf of Mr. Brown, and so, but knowing that this had already been continued once at the request of Ms. Poplowski, we are on board with the guardian ad litem's recommendations, and that reflects our position as well. We would like counseling to take place through Columbia Wellness if possible. And father does have some concerns with the use of the Cowlitz tribe for counseling. I'll reserve any argument if needed to respond, but that accurately reflects our position.
All right, thank you. Ms. McLean?
Thank you very much, Your Honor. So originally this matter commenced with protection orders, and at that time, the child was counseling with Celia Delaney, who is a counselor with the Cowlitz Indian tribe. Lauren is a registered member of the tribe. She's able to receive services at no cost through the tribe. And obviously it's appropriate for her to be able to receive identified counseling with providers that are tribal members or at least affiliated with the tribe. After the protection order, Lauren qualified for grant funding for counseling with Patricia Anderson. She had participated in a CJAC interview and she qualified for those services. So Patricia Anderson was originally providing those services under the grant, which meant then that these folks didn't have any cost affiliated with Patricia Anderson being involved. After the grant, either the grant time ran out or the grant funding ran out, and it was agreed at that point that Lauren would remain with Patricia Anderson, at that point private pay. She was also still meeting with Celia Delaney. She had established therapeutic relationships, arguably with both Ms. Anderson and with Ms. Delaney. And then we had a hearing in, I believe it was in October of 2023, that was heard by Judge Fassett. And ultimately, Judge Fassett, this was in regards to the reunification counseling that was being recommended. It was determined that Lauren needed to have a consistent therapist at that time to participate in that reunification process so that Lauren had a sounding board. It was determined that that counselor at that time would be Ms. Anderson. Obviously, Ms. Anderson is housed within the same facility as the reunification team. She's part of Charlotte Rosen's team. And so there was sort of that readily acceptance by the court that Patricia Anderson would continue with that. You then see Ms. Anderson's letter that Lauren is continuing to act out emotionally. And Ms. Anderson's belief was that that was because Lauren was identifying the location where Patricia Anderson is housed as the same reunification location, and that was having a deleterious effect on their therapeutic relationship. So Ms. Anderson earlier this year submits this correspondence that she's done. She doesn't think it's in Lauren's best interest. And so Lauren's left without an individual counselor because the court had indicated that it would be best for Lauren to have one counselor, and Celia Delaney then exited as of, I think it was either late November or December of 2024. So fast forward, we now have a child who continues to act out during reunification. She needs to have an individual therapist in order to decompress. And Ms. Day has recommended either an individual with Columbia Wellness or an individual, and I can't remember the other one, but Core Health, Columbia Wellness or Core Health. And Ms. Day did some research. She made recommendations for Columbia Wellness. Of course, there's a cost affiliated with Columbia Wellness. Both Columbia Wellness and the tribe, and I assume CORE as well, in order to meet their own state mandates, they're required to go through a process of interviewing and evaluating the child and significant others in order to come up with a diagnosis and a treatment plan. You can't just go in and have treatment start for a child without there being appropriate check marks, T's crossed, I's dotted, to provide counseling services for a child or for any adult for that matter. They have to comply with insurance requirements. In order to be able to bill an insurance company, they have to have an identified diagnosis and a treatment plan. So my client did some additional research. Again, her position is that it would cost these parties nothing, zero, in order for Lauren to participate at Cowlitz Tribe for purposes of counseling. And they do have an individual who is available, Kelsey, and I'm hoping I'm pronouncing her last name correctly, Gravel. She is available. She's taking new clients. She would have to go through that interview process just like any counselor would have to do at Columbia Wellness in order to start any type of treatment or to commence a therapeutic relationship with the child. And we're proposing that it be the tribe because that's not going to cost these folks anything. These folks, I'm going to just speak for both of our folks. They've got 2 suits sitting here. They've got a GAL that they've paid for. They've got the reunification team that they're paying for. They've got supervised visitation through Beth Fellis's facility, reconnecting families that they're paying for. They've got a minimum of $3,500 a piece that this court has now ordered them to pay in order to participate in psychological evaluations with Dr. Poppleton. They are bleeding. They are hemorrhaging money. And if there's any place where these folks can potentially save some money, they need to do that. And that's what my client is asking for, that we allow Lauren to access counseling at the Cowlitz Indian Tribe, which is going to be free to them. Mr. Brown says, well, I have an objection. There has been no legitimate objection raised. He previous or early on in this case, his claim was that my client's mother works for the tribe and therefore she's affiliated and knows these people and they're going to be swayed because of that. My client's mother does not work in the same building as the counseling agency or the counseling portion of the tribe. She doesn't know the counselors. She's not spoken to the counselors. If you want to enter an order that says petitioner's mother shall have no contact with the counselors for the child or go into the counseling agency when she's present, great. We have absolutely no problem with that because it's not grounded in actual fact. Mr. Brown's claims are not founded in actual fact. There is no conflict. So we're asking to start her with the tribe. And then the question becomes, how do we provide sufficient information to make sure that this counselor is aware of as far as all of the working processes here? Because ideally, what Judge Fassett envisioned was that, and if you go back and look at the court order, Lauren was originally to have 3 visits with Patricia, and if there were concerns from those visits from Patricia Anderson, she was to reach out to the parties and to the reunification team for us to have a hearing before reunification started. So the expectation is that there's this open door communication between the child's counselor and the reunification team so that things can be basically expressed if there's ongoing concerns, as well as providing that information to the guardian ad litem and the parties and their attorneys so that if the court needs to step in, then we can do that. So I guess we need to have some mechanism for that free flow of anticipated communication between all of the involved parties for this child. And we need to make sure that the counselor has appropriate information as far as why they're being involved. That, I'm assuming, is going to be part of what their treatment plan, their diagnoses and treatment plan would include. Now, if that means that Ms. Day is present during the intake with the child and my client, because my client is the primary parent of this child, then so be it. But it's not like a counselor is going to do a 1.5 or 2 hour interview with just the child and rely upon, if I recall correctly, she's 6 years old, to provide accurate information of what's going on. Obviously, a parent is going to be involved in that in some respect. So I guess we leave that to the court, but we need to make sure that parents have the opportunity to provide necessary information, answer necessary questions that the counselor has in order to arrive at an appropriate treatment plan.
All right, thank you. Anyone else have anything else?
I just had one brief point if I could make in response, Your Honor.
Go ahead.
I just wanted to note that Mr. Brown is not opposed necessarily to using the tribal clinic. The issue here and his objection, which should be noted, is that potential conflict of interest that was noted by the guardian ad litem, not something fabricated by the father. The specific counselor proposed has had an involvement in this case, as well as just the validation of the tribal clinic notes. Multiple judges in this case have ruled that while Lauren can receive services at the tribal clinic, the notes from those sessions hold less or no validity in this court proceedings. So he's not opposed to the center per se, but we would ask that if that's the case, then that second counselor proposed by the mother be used. And again, just note that that is our concern. This isn't something fabricated by the father. It's been raised by both the guardian ad litem and by the father. Our understanding is that Columbia Wellness, as a separate option, would accept mother's insurance and could be a cost-effective option as well. And then just lastly, on the intake process and some concerns raised there, we agree that we would like the allegations that have been made in this case and some of that background to be left out. It's understandable that the parents may need to have some influence in getting the counselor up to speed in this case, but we would ask that any of the allegations and the case history of this be left out of it and that it be focused on what the child needs and on Lauren's wellness, not on the allegations made in this case.
All right, I didn't understand the reference to judges saying that the counseling notes at the tribe didn't have any weight, or I guess I'm not clear what you meant by that, counsel.
Just that this counselor that has been proposed, Celia Delaney, there's been some rulings in this case history that her notes aren't to be considered because they do include references to those allegations. And if I'm misstating, counsel can correct me. Like I said, I did substitute into this case, so that's my understanding. But if I'm misstating, please correct me, Ms. McLean.
Yeah, I'm not aware. So I would direct the court and counsel, and I can forward counsel a copy of this order. It's the order restraining order and reunification. And I think there was an amended one entered after this, but it's entered, let's see, it's clerk's paper 76. And hold on, because I thought that there was an amended one. Oh yeah, clerk's paper 79 is the amended one, but the language remains the same. And this is on page 2, paragraph 6C, number 1, where it talks about Patricia Anderson being identified as a separate and distinct counselor for the minor child as she goes through the reunification process. It says identification of Patricia Anderson as the distinct counselor for reunification services does not prohibit the child from maintaining her counseling relationship and appointments with Celia Delaney. So there wasn't anything entered that her information shouldn't be considered. And in fact, if you go back and were to look at one of my clients' prior motions as far as requesting that the reunification stop, one of the main concerns about Ms. Anderson was that her notes consisted of like 2 or 3 lines, period. Ms. Anderson's notes talked specifically about the interactions with the child. They were, 2 or 3 pages in length, gave us a lot more detail and information. And so that was one of our concerns previously, but there's nothing entered that I'm aware of, or that I recall, that said that the court shouldn't consider Celia Delaney's information. And previously, as of, like I said, November or December of 2023, she had a therapeutic relationship that had already been established.
Your Honor, if I may.
Yeah, and I have a question, Ms. Day. How does, I guess your proposal that the intake be somehow, it seems like almost like there wouldn't be an intake in what you're proposing. Well, a child would just start to meet with the counselor and
well, my hope would be that just there would be some guidance given but from the court. So I'll address that, and then I want to address the Celia Delaney situation just a little bit. My hope was that because of the amount of information and the weight of the allegations, it has significantly impacted not only the relationship between the child and her father, but also involving the professionals. And so my hope was that if we're going to have an in-person intake, that there be the opportunity for both parents to provide input, and that the court limits some of that so that the attorneys are not providing reams of paper, which is some of the things that have happened in the past, as well as just a regurgitation of these allegations that have been ongoing and unfounded at this point, and still. And then that brings me to the situation with Celia Delaney. Lauren did have a therapeutic relationship with Miss Delaney, and I don't find any fault with Miss Delaney as a provider herself, and I'm not suggesting in any way that she's done anything inappropriate. What I would suggest, and I think the notes are very, very clear, is that much of Miss Delaney's contact involved mother being in the sessions or separate with mother on the phone, and mother making the reports involving the sexual abuse. And that is where the conflict comes, at least from my perspective. Mom is reporting to Miss Delaney what she says Lauren is saying, and then those are being reported to CPS, resulting in multiple reports when there's really only been one true disclosure from this child. That happened very, very early in the beginning, and that was noted by Miss Delaney as an independent disclosure through all that whole situation in the beginning. That's my concern, is Lauren needs to have support and therapy to help her process what she's going through now and currently with what the decisions are and the reunification. And if she's struggling and not able to manage, we need a provider who's only looking at what Lauren needs and not being inundated with all the allegations from both sides. Father has his circumstances and what he believes is happening. Mother has hers. And what's happening is Lauren is lost in the middle. And that's my concern. So my request is that the intake be somehow limited. I think it's appropriate to restrict the grandmother from having contact with the provider. I would also ask if the court's going to go with the tribe, which I don't object to, that there also be limitations with mother's independent provider. The therapist should be having contact with the reunification team, with Charlotte Rosen specifically, as well as myself and the parents. I think that the focus has to be on Lauren. That's my concern. And the level of conflict in this case just continues to grow, and Lauren is the one who's lost in the middle.
And I guess the only comment that I would have in regards to that is I don't have any independent recollection of ever speaking with or emailing Celia Delaney. I just briefly went back and looked through my email thread. I don't see where I've sent her any emails. I don't think I have any notes of discussions with her. I had received her counseling records. I think those came directly from my client, if I recall correctly.
Okay.
Yeah, I'm sorry. I did speak to Celia Delaney on February 7th of this year, after she had already been released.
All right, I'm going to enter an order that allows for individual counseling with Lauren and Miss Gravel at the tribe. That order should include the provisions about the grandmother not having contact with the provider. In terms of the intake, I suspect that the counselor has a protocol they follow, and they should basically dictate what the intake process looks like. And I would authorize Ms. Day to take part in that. If that process involves the parents each meeting with the counselor, Ms. Day can be present when those occur. And I think that will have, hopefully, just we can get across to the counselor that the child basically just needs a place where she can deal with what she needs to deal with without of everybody else having a say in what they think she needs to deal with.
Thank you, Your Honor. Do you want me to prepare that order, or are you going to do a bench order?
Well, I would need somebody to prepare the order at this point. So I guess you're the moving party, Ms. Day, so.
And one clarification question, Your Honor.
Go ahead.
Is the court's ruling that if the intake process is to meet with the parents, that they meet with both parents?
Not at the same time, individually,
Correct.
with Ms. Day present.
Correct. Thank you.
Yes.
I'll get an order prepared and sent out to everybody no later than tomorrow.
Okay, thank you.
All right.
Thank you.
And that will conclude the docket. So I'm going to end the session.